All right. Welcome, everybody, to episode 21 of Sports Shorts. I'm your host, Bobby Hacker, former president of the SLA, actually the immediate past president, longtime board member. And my guest today is not only the Louis H. Vovakis Distinguished Faculty Scholar, Professor of Law, and Executive Director of the Penn State Center for the Study of Sports and Society, but he is here in his capacity as a Berkeley class of 1976 reunion, my dear friends, Professor Steve Ross. Welcome. Well, it's great to have you today, Steve. The way we like to start out our show usually is to find out a little bit about our guest. And I think in your case, you're a law professor, and based upon the center that you're executive director of, I think people have an idea of what you're doing, but a little bit about sort of, your academic background and how does a guy who starts out in DC end up becoming a sports lawyer?
So it's great to be on this really great series that you're running, Bobby, and just a delight. So I grew up as a huge sports fan, hit 083 in Little League. Knew that it was going to be outside the lines that I was going to be involved in sports. And the first opportunity came when I was working as a attorney in the antitrust division of the Justice Department, where we had some sports antitrust issues. And since I was such a sports fan, I got to work on a couple of cases and saw some of the interest there. And then I went to the Senate Judiciary Committee, where once again the NFL was always seeking exemptions, and baseball was people were trying to get rid of the baseball exemption. So there were a lot of sports antitrust issues that came out of that. The second thing, for your listeners who think that antitrust is like tax and it's a big mystery, and if you're not doing it, they can't understand it, I beg to differ. And to me, antitrust is not only really important for how so many of our rules are shaped, most prominently today, the Alston case and what's going on with the NCAA. But if you understand antitrust cases, to really understand them, you need to understand the business. So if you're, especially for younger sports lawyers, one of the reasons to learn antitrust is not because you're going to get to work on antitrust cases or complicated cases. You could be in baseball where it's still exempt. To learn antitrust cases helps you understand the fundamental dynamics of how the sports business works. And if you can understand antitrust really well, you will understand how the sports business works. And so that's how I got into it. The second thing I did, so I'm a professor, and I was brought in by the British Office of Fair Trading, like our Federal Trade Commission, to work on a competition law challenge to the first TV contract, where they took all English Premier League games off free to air, and we're going to give 60 of the matches to Sky Sports, Murdoch's cable channel. And they were prosecuting it just as a regular, normal cartel. And the English Premier League said, we're not a cartel, sports are different. And we always, people reject that. But then they said, look, we turned down 50% more money, pure profit, to show 30 more games. This shows that we're not operating like a normal business. And so the investigators found that was absolutely true. And the reason is because they couldn't agree on how to split up the money. So for the past 25 years, one of my main areas of research, and requires me to learn how sports work, is to look at all the ways that sports leagues and clubs struggle to overcome the fact that you got to get your competitors to go along with your ideas in order to innovate. And that's been a big part of my work, which has led me beyond academics to doing consulting for the Indian Premier League, which is the most successful cricket league around, and for a number of other sporting organizations in the US and overseas.
I'm really happy to hear you make that comment about antitrust, because it's one of those areas that you're right. People go, oh, can't figure it out. But the reality is, for years now, in speaking with law students in particular, and they say, what classes should I take? And the two groans I get are labor law, which seems to be harder and harder to find anybody teaching, and antitrust. And I explained to them, for the very reasons that you did, is that there are fundamental realities, certainly in America, regarding competition. Competition is good. When you eliminate competition, light bulb has to go off. Does this, the rule of reason's called that because it's pretty reasonable. Does it do what we don't want it to do and inhibit competition? So I think when you get those sort of 30,000-foot views of the relationship to those laws to sports, it makes all the sense in the world. And I to my mind's eye, it also at least has a sense of creating competitive balance. I don't know if that's an unintended consequence or a goal, or.
It's a great point you make. I'll just have just three quick responses. One is, I just did a webinar last week with some German lawyers on salary caps. And it is absolutely clear you cannot understand what's going on in the United States unless you understand the fundamental principles of labor law in the United States and how unions are authorized to be the exclusive negotiating agent for everyone in the bargaining unit. And if you don't understand those principles, you can't possibly understand American salary caps. Another example is, there's a couple of great Australian cases involving rugby, and where the court talks usefully about two different markets: the market for competition organizing services, which is what a league does, and the market for participating in a competition, which is what clubs do. And in the US, we never think about it like that because they are what economists would call vertically integrated. The National Football League clubs provide their own competition organizing services to themselves, just like Apple provides the same stuff to Apple Store in an integrated fashion. But we just assume this stuff is true without really thinking through the details. So I think that's why that's sort of important. And then when you talk about the rule of reason, I think it really helps you focus on things like competitive balance. And everybody says, oh, we need more competitive balance. But if you look at the La Liga, there is no competitive balance in La Liga, and it's growing ridiculously. There is no competitive balance in college football, and it continues to grow ridiculously. So it really makes us think more rigorously about what are we actually advocating for when we argue for competitive balance, and why is it that competitive balance is a good idea, and all those things, which is what all sports lawyers talk about. Antitrust just helps you think about it, even if you're not litigating a particular antitrust case.
Yeah, and I think I'm glad you sort of segued me into the topic of college sports, because I would say in the last 6 months, it's like a Roadrunner cartoon, and the Acme company has dropped a giant anvil on the college sports scene. And you see it across the Alston decision with the absurd Kavanaugh concurring line. What's going on with NIL, which is, I have questions on how NIL works with respect to enforcement under the Commerce Clause, which is a serious legal issue that, you got to think about, especially when you had, those, what was it back in the 90s, the Rehnquist court, shrinking federalism by saying, oh no, it doesn't have a real impact on commerce. And you look at just some of those issues, and then the general counsel of the NLRB making the pronouncement in just an opinion that, oh, no, they're not student athletes, they're employees. So you put all of that together, the state of college sports has never seen a point like this. And it touches on, it's like take the cornucopia of legal issues, pour it on the table. Welcome to college sports.
Well, you're almost right. As an academic, I'll quibble. I think college sports was in a greater disarray in 1906 when President Roosevelt was going to think about abolishing sports. But you're close in the sense of disarray.
Well, he did help to abolish American football. He did lead that, which of course allowed rugby to be the preeminent contact sport of the era until 1914. So,
well, if we want to really sort of get into it with some of our California friends, as you know, the presidents of Cal and Stanford decided that American football was just too troublesome and dangerous and went to rugby for a number of years and only had to go back to American football because USC decided that its national fame would be joined by playing against Notre Dame and the like, and so they followed suit there. To me, I'm now going to sort of flip what I just said about how you need to understand antitrust law to understand all the legal issues. Here, the problem in college sports is really not all the completely complex, nuanced legal issues you're dumping on college sports. It is the systemic cultural problem of a cartel. And we have a mutual friend who spent a lot of time involved with the NIL issue before the Alston case and everything fell apart, working on sensible solutions with the 5 general outside counsels appointed by the Power 5 conferences. And it was a fascinating experience to hear our mutual friend discuss, because the Big Ten lawyer could not agree to anything unless all the Big Ten members would agree. And so, of course, they couldn't agree to anything because there really isn't anything that Penn State and Illinois would agree to. And then, of course, there isn't anything that they would agree to that the SEC would agree to. And so one of the reasons that you continued this decades of exploitation of college athletes was that no one could agree on the solution. And, as I said, now our former Cal athletic director, Sandy Barber, discussed this with me. And I said, look, if you went into a room with Senator Cory Booker, the ranking Republican, and the guy from that represents the football players, you know who I'm talking about, the guy who's in the organization that is like,
yeah.
Anyway, I'm blocking on his name. But if the 4 of you went into a room for 5 hours, you could come out with federal legislation on NIL rights that would be a solution. And if Josh Whitman from Illinois went in, he could come up with the bill. And if Jim Knowlton from Cal went in as the 4th guy, he could come up with a bill. You could get this. The problem is they're different bills. And that still isn't a problem if Congress could just decide what to do based on whose interests they want to favor and whose interests they don't. But the problem is that the president's athletic directors, nobody will say anything unless everyone else agrees. And as long as college football remains in this complete fix of we're the cartel, there's just going to be continued chaos. And we're going to be fun for lawyers because we're all sorting out all this stuff, all the issues you talked about.
Yeah, well, we're looking at now, we've got, I don't know how many states have enacted legislation in NIL. It was 12 or 13, and there was a bunch under consideration. But now we get into, my professor friend, the potential of a nightmare conflicts of law question, because if I'm a resident of California playing football in Mississippi and doing promotional work for a company in Illinois, as the joke goes, where do you bury the survivors? I mean, you look at the contract and the contract says this law applies. But if I'm a student in a state that doesn't have NIL rights, am I permitted? So the bottom line is, I don't know what the answer is. I know there's a lot of issues. And the troubling thing to me is what's it going to take to get national legislation? Because it seems to me the Alston case said we need national guidelines, but NC2A, they can't come from you.
Well,
And the NC2A put out their guidelines. They're not enforceable, really, are they?
well, you bring up there's a chaotic problem, and I think the current policy of college administrators is we are still the cartel. We will not take any position that doesn't benefit all of us basically at the expense of college athletes. So we're not going to get involved in just trying to lobby for Cal's interests, Penn State's interests, Illinois' interests, whatever. We're not going to do that. What we want is Congress to act. Well, Congress is not going to act in the normal case. So now we're going to hope that the vacuum becomes so chaotic and so terrible that Congress will have to act. I still don't think Congress will act. So when you say what has to happen is individual firms, universities have to stop acting like a cartel. They ought to just lobby for their own thing, and then Congress can do what Congress can do in that situation. I think there's solutions to the choice of law issues. I think the real problem, and what is to me so hypocritical and inexcusable about the NCAA, is they had a workforce chaired by a great hero, Val Ackerman, one of the great sports lawyers of our time, which had two parts. One was we're still a cartel and had all sorts of anti-competitive, terribly restrictive, unjustifiable rules. And then they came up with an incredibly workable way to implement NIL rights. And after Alston, the NCAA said, we're going home. There is absolutely nothing in any of the state laws or the antitrust laws that would have prohibited the NCAA from designating a respectable organization as a clearinghouse and announcing that it is absolutely a violation of NCAA rules for any athlete to receive a penny from NIL rights, unless it's pursuant to a written contract filed with this clearinghouse. That's not an antitrust violation. It's not a violation of any of the state laws. They could have created this working group so people would get to understand what fair market value is. People could see exploitive contracts, all these other things. But and it's not like the NCAA would have had to make it up. It's in half of Val Ackerman's report, because since they couldn't have the other half of the report, they just went home. And so to me, that is really inexcusable, and that is a real problem. And conferences and others are going to have to figure out how to step in to deal with some of the real abuses that are going to happen because the NCAA is throwing a temper tantrum.
Well, which begs another question, which I think has been brewing for all of us watching the college sports scene over the last several years, is does the NCAA really have any strength anymore? Does it have any value? The conversation has been, the Power Five conferences are going to create their own football universe, for example. There's a million things you've heard about, and the question becomes: everybody wants to focus on the sports that bring in money, football and basketball. You get a little from everywhere else. But, there's a lot of universities that have 22 to 30 varsity sports under the governance of the NCAA. So can they exist does the organization exist without governance over football and basketball? Do you think it survives to manage the so-called Olympic sports or other sports?
Of course they can. And in fact, if it wasn't for a blatant antitrust violation, we'd already have a case of this, because back in the Board of Regents case, the landmark Supreme Court case in 1984, one of the things that the College Football Association wanted to do is simply pull out of the NCAA for the purposes of college football, which they not only have a clear right to do under the antitrust laws, but they had a clear right to do under NCAA rules, because the NCAA defines their jurisdiction as just varsity sports. So right now if we organized a college cricket in the United States, it wouldn't have to be under the NCAA. They could just create the College Cricket Association and do it, and there wouldn't be any problem. What happened was the NCAA said to the CFA, if you do that, we are kicking you out of the NCAA for all the other sports. That's blatantly illegal, but they did it. There was no way to prevent it during the lawsuit. And then after the Supreme Court victory for the College Football Association, then they sort of made up. But there's absolutely no reason that you can't have a organization that regulates different sports. In fact, Gary Roberts, former president of the SLA, and my former co-author, he has suggested that there ought to be a National College Football Association, a National College Basketball Association, and then other individual sports can just decide on their own whether they want to be regulated by the NCAA or whether we should create a National College Swimming Association and a National College Golf Association to come up with their own terms and their rules. And that's just a matter of what people want to do.
In this interesting new world of NIL, which, I mean, we're sort of watching the gestational period of what seems to me to be a sea change in college sports. There's a couple of things that concern me. Is there are states that have legislation. So you go to the legislation, you know what the rules are regarding it. You're in a state, there is no legislation, and somebody says to you, hey, Billy Bob Bobby, you're a great wide receiver on the university of the state that doesn't have a rule. We want to pay you some money. I'm paralyzed. I mean, I should be paralyzed. I'd probably take the money if I'm a student athlete, but what law controls? There's no national law, but there's no state legislation.
Yeah, I think I look at it in a slightly less paralyzing way. I start with the view that the student athlete, the law gives the student athlete their right to their own name, image, and likeness, and so they want to sell it. So that's number one. Now, traditionally, the NCAA came along and said, no, you can't do that. So, and then third, states like California and our classmate, I don't know if you know this, Nancy Skinner, the author of SB 206, also Cal class of 76, says any school in California, you can't listen to the NCAA. So now you're back to square one if you're in California. And now the NCAA, after Alston, says, we're not doing anything. So my answer to the athlete is the NCAA has said, you're not doing anything. And they're not doing anything. You have these NIL rights, so go ahead and do it. And now if your school says you can't do it, that's a whole other, now it gets a little more complicated with what's going on. So I check with the school, but fundamentally to me, I start from the view that everybody's got the right to their own name, image, and likeness, and they should be able to do whatever they want with it unless they've voluntarily given it away. There's also, I'll just take a moment to say some myths here about this, which is what this legislation says. There's nothing in any of this legislation that limits the ability of schools individually to, as a matter of contract, impose restrictions on players. So if Cal wants to say, and any restrictions they want, basically, Cal wants to say no player who receives an athletic scholarship from Cal can ever endorse any product where the corporate sponsor is a Stanford sponsor. That is a perfectly legitimate thing for Cal to say if they want. Now, they might lose some student athletes, in which case they might not impose that restriction, but they're absolutely free to do that. It's now an open negotiation. So I think some people are now of the view that student athletes can just sign whatever they want with whomever. But if they're getting a scholarship, they need to check their relationship with their own university and see what's going on there.
Which begs the question, have, anecdotally, or do you know any reports about the universities, the member institutions of the NCAA establishing educational programs for its student athletes? Now, I've spoken to some athletic directors. I spoke to your student and our colleague and friend Josh Whitman about Illinois and the program they've put in place, and just it happens so quickly. And you now have to advise all of these student athletes not to lose their eligibility, which is what's really at risk.
Well, there's a lot more at risk than their eligibility. We're doing a lot at Penn State, both to facilitate how people can do this, what the risks are in exploitive contracts with people who are granting your rights or agents helping you do that. And then there's huge tax issues. So there's already a huge problem where a number of student athletes are granting NIL rights to car companies in return for free leases, which is perfectly legal now, say in Pennsylvania or California, to do that. The problem is you're on a free ride to Cal or UCLA or whatever, you're cruising around in your car in return for your NIL right. Well, that's taxable income. And next April 15th, they're going to get hit with this sizable tax bill. So there are things about that. How you structure when you do more than just grant your rights. If you're doing appearances and royalties, like on a shirt or something like that, there's complicated tax and other issues about how you set that up. So there's all sorts of really troublesome and interesting legal issues. And frankly, I think losing your eligibility is really the lower risk here, because both your school and the NCAA is so fearful of it. Your school doesn't want to take away your eligibility anyway. And B, if they're doing it pursuant to a conference rule or an NCAA rule, they're worried about antitrust liability. And the NCAA is throwing a temper tantrum. So I think, I'm not saying that there's no risk there, but I think the legal risks to a student athlete who goes in and signs an NIL deal about unknown tax liabilities and a bad deal if they become super famous and now they're stuck in a deal that isn't so great, and they signed a deal with somebody who may not be the best person for them to promote their endorsements, especially at some later point. And then, my former student, Mark Steinberg from Excel Sports Management, comes in and says, oh, we'd like to pair you with Tiger Woods in some endorsement opportunities. And they can't do it because they're tied to some agent relationship with some buddy of theirs. I mean, those to me are the much greater risks.
Well, it's really interesting. And I think that, in much the same way that my soapbox moment here, that we used to all learn government or civics in school, and that has been eliminated from schools. We certainly need to bring that back, but we also need to have financial literacy education so that when a kid gets to college and it's the first time that most people are on their own, that you should have part of the introduction to a student is, here's the reality. And certainly in the space that the athletes are occupying, any state where they have an NIL legislation, it seems that the school has to start with what you were talking about, financial literacy, which is to say, it's really great that you now have a new BMW to drive around, but come in April, you will have had 5 months of $500. Now you've got $2,500 of income. I didn't get any money. Yeah, well, I
think you're right. I'm going to be provocative and suggest this would be a great program for the SLA to think about, but somewhat contrary to the interests of many SLA members. And that is the lack of financial literacy is, I think, exacerbated by the change. Well, it's really like over the last 30 years in what lawyers do to represent clients, which is from I'm your lawyer and I'm going to help, and an agent. I'm going to help you find clients, employers or sponsors, and I'm going to negotiate your contract with them. That's what I do as an agent. To what I call the concierge model, where I'm going to do those legal things as your legal representative, but I'm also going to have a whole team of people in my agency to take care of your life and basically be your butler. And this evolved competitively in order to attract clients. But the result is there is a complete lack of literacy about anything. And this is not just for 18-year-olds. I remember a story when I was at the University of Illinois about a hiring of a football coach who was a former professional player. And the guy did not know how to buy a house or find a mortgage because his agent had always taken care of all this. This is a head coach of a Power 5 team. Very smart guy. But he had never learned any of that because he always had some agent to take care of it for him. So I do think there's a lot in what you say about legal and financial literacy.
Well, Steve, needless to say, you and I, as we have, could talk for hours and hours. There's a whole list of subjects I didn't get to. A lot of interest piqued in your recent webinar you did with an Irish former international rugby playing woman who's at the international rugby. And so hopefully we'll get back and we can maybe spend a little time talking about comparative law issues that are really fascinating and in the different models. And before I sign off, I just want to remind everybody that if you go to sportslaw.org is a place to go to sign up to become a member of the SLA and obtain all the benefits, because not everything is, I hate to say free, there's things behind our paywall that are worthwhile having, a lot of materials there. And also to just keep you informed that we have a new initiative at the SLA. It's called Time for 9, which is a celebration of Title IX's upcoming 50th anniversary. As you all know, it's a landmark legislation prohibiting discrimination on the basis of sex. And we're going to be going through a series of programs from now to the actual official 50th anniversary on June 23rd, 2022. So there'll be a lot of webinars, discussions, and whatnot on the subject, because it changed the face of sports in our country for sure. And I think the impact around the world is pretty wide, and maybe a subject we can talk about at another date. So Steve, thank you so much. Really appreciate you taking the time, and we'll chat soon. Thanks everybody for joining us.
Take care. Thanks a lot, Bobby.